Hello, and welcome back. I know we only had one lecture last week. I'm going to upload 2 lectures this week. And then next week, we are going to have our first quiz, or our first exam. I'm going to do it kind of the same way that we did the quiz. I'll upload it. Betsy's with me again today. Say hi. I'll upload it. My plan is to have it uploaded on Monday and to give you just a couple of days to take it. I'll let you know the next video how long you'll have to take it. And it'll be the same way that the exam or the quiz was. Once you start it, you'll have a certain amount of time to complete it, and then that's gonna be it. Unfortunately, I can't do makeups for the exam or for the quiz because it does expire after I've posted it. Once I list a time for it to expire, it will expire. A couple of you had emailed me about making up quizzes and things like that, and I'm sorry, this is not feasible. This is a college class. Things are pretty serious. So we will have that. I will post that exam. I'll give you a heads up when it's going to be posted. I know I didn't give a whole lot of heads up for the quiz, but I will for the exam, and know that it's going to be on everything that we've covered up until this week. So basically the first 6 chapters, maybe your numbers are not exactly right, but everything up on the syllabus until the end of this week. The exam will be mostly multiple choice, and there may be a couple of like a fill in the blank with a word bank if I can figure out how to do that. If not, it will be multiple choice. It will be a lot longer than the quiz, but in kind of a similar vein. What else? You'll have a little bit longer to take it than you did the quiz because it will be longer, but still know that it is a timed thing, so make sure you study beforehand. And if you have any questions about it, please let me know. I will let you take it whenever you want to. I'll do the same thing like the quiz. It'll be up and available for a couple of days, but once you start, make sure you have time to complete it because it will expire. Okay. Today we're going to talk about fundamental American liberties. So what's at stake in things like regulating gun ownership? That's something we're talking about right now. Also, first I want to address Ruth Bader Ginsburg passing away. That's a very major deal in this country and politics, and just in the way that she shaped our country. I mean, what a tremendous loss, and I did want to take a moment to honor all the work that she's done. We're going to talk about the Supreme Court later this semester, and I will talk about her a little bit more. It's going to be really interesting in my career as a lobbyist to watch what they're going to do about replacing her. As you know, the Senate in 2015 did not fill a vacancy because it was the end of President Obama's term, and so Mitch McConnell, who's the majority leader of the Senate, is a different party than he's a Republican, and obviously President Obama was a Democrat. He did not fill that seat. He waited until he made kind of a gamble that Trump was going to be elected and he would get a Republican to fill that vacancy. And so now it's kind of the same thing happening. Like, it's the end of a presidential term. Should he take up this president? His argument is kind of not valid anymore, but now he knows that he wants a Republican to fill that seat, and he has a Republican in the presidency right now, but maybe won't in January, so he's trying really hard to push through a nominee. So it's kind of interesting to think about precedent and what happened 5 years ago as opposed to what's happening today. So watch for that in the news. I think it's really interesting, and I'm going to be interested to see how that shakes out. If we can push a nominee through before Election Day, it's going to be really interesting to watch. All right. So in December of 2012, at Sandy Hook Elementary, there was a school shooting in an elementary school. It was really terrible. President Obama at the time vowed to outlaw assault weapons. He formed a task force on gun violence with Vice President Biden leading it. He proposed that Congress pass legislation banning assault weapons, etc. There was a former Congresswoman, Gabby Giffords, who had been shot, and she formed a group called the Americans for Responsible Solutions. Michael Bloomberg has formed something called Every Town for Gun Safety. There is something called the Brady Campaign to prevent gun violence. They received record donations, but nothing happened. If elementary school students can get shot and nothing happens, like, it's just crazy to think about. John Boehner was the Speaker of the House at the time. He expressed regret, but did not promise action. He was a Republican Speaker of the House, and couldn't get any legislation through at the time. The Senate had a compromise bill on background checks, and it failed as well. So you think about, this is a fundamental American liberty to have a gun, but what's at stake. So we'll think about that a little more as we go through this lecture. Ooh, my phone is in the way. Okay, so at the beginning of the Revolutionary War, Patrick Henry said, "Give me liberty or give me death." Americans put a lot of stock in their freedom, certainly in the way that they live in the least restrictive country in the world. But we collectively live in a government, which means we aren't free to do what we want. We have limits on our freedom that allow us to live peacefully with others instead of the chaos of everybody else doing exactly what they want. John Locke said, "Liberty does not equal license. The freedom to do some things does not mean the freedom to do everything," right? I can tell my 4-year-old son, you can go outside, but that doesn't mean you can go run down the street, right? Like, he has the freedom to walk out and play in the backyard, but that doesn't mean I have given him the freedom to do whatever he wants, right? Deciding what rights we give up to join a civilized society and what rights we retain. This is a great challenge of democratic government. So we have civil liberties, which are individual freedoms that are guaranteed to the people primarily by the Bill of Rights. We can act without government interference, choose our own religion, and then civil rights. These are citizenship rights guaranteed to people mostly in the 13th, 14th, 15th, 19th, and 26th Amendments that are protected by the government. And that's usually an extension of government action. It usually means that government has to treat all citizens equally, apply laws fairly, and not discriminate unjustly against certain groups of people. So you can distinguish between an authoritarian government and a non-authoritarian government. I have the hardest time saying that. Non-authoritarian government, including democracies, give citizens the power to challenge a government if they believe it's been denied their basic rights. Democracies depend on the existence of rights. Civil liberties provide rules that keep government limited so that it cannot become too powerful. Civil rights define who we, the people, in a democracy are, and it gives those people the power necessary to put some control over their government. So in a democracy, we take a lot of freedoms for granted. We speak confidently of our freedoms of speech, etc., but nothing is inevitable. John Locke brought about the first real discussions of rights at all during the Enlightenment. He said nobody claimed rights against the government. They thought the government had all the power and it only gave subjects privileges they were willing to bestow. He said we had a right to life, liberty, and the pursuit of property, and those were conferred by nature, and the government should preserve those natural rights of its citizens. This was central to the founders of our government when they founded America. So practically speaking, a government can do whatever they wish as long as they remain in charge of, like, the police and the military, right? But public opinion is outrage at invasion of individual rights, and unless a government is willing to dispense with this reputation as a democracy, it must respond in a way to pacify public opinion, which can be a powerful guardian of citizen liberties in a democracy. A person who can successfully claim that he or she has rights must be respected by a government as a citizen of that government. A person who's under the authority of a government but cannot claim rights is a subject, bound by the laws but without any power to change them. So we are citizens here. We have the rights. We have rights, but we can't. That have to be respected, but we can challenge them. That doesn't mean as citizens we can always have things our way, but it also doesn't mean that a non-citizen doesn't have rights in a democracy. Sometimes this conflicts. Sometimes there are times that where rights can conflict. The first type of rights conflicting occurs between individuals. One person wants to pray with classmates, another student doesn't want to be subjected to religious practice. The second way is when the rights of individuals are pitted against the needs of society and the demands of a collective living. So the decision to wear a helmet or a seatbelt, it seems like that's an individual decision, but society has an interest in regulating those behaviors because jeopardizing one's safety is costly to society in terms of maybe a loss of talent, wasted public investment in a person, cost of medical care, etc. One of the most important aspects of claiming and defending rights is building and perpetuating a narrative that the right you claim exists and that you deserve to have it. Sometimes rights conflict. So after 9/11, Americans were very afraid. So the government federalized airport security and started screening passengers, kept a close eye on folks suspected of having ties to patriotism. And the 2001, the Patriot Act made it easier for law enforcement to do things like intercept an email and conduct a roving wiretap. This may have increased the security of citizens, but it really reduced our civil liberties. But we were at threat at the time, and so most Americans thought it was okay. Somehow a reduction in freedom doesn't seem unreasonable for a reduction in fear. We were afraid for our country, so we were okay with the government screening us at the airport and things like that. And still, to that degree, somewhat. In the delicate balance between security and freedom, which side should we err? It's hard to think about. Balancing the public opinion, the safety of public individuals is complex. We could more likely ensure more safety from threats if we gave up all of our freedoms, if the government could monitor all of our movements and know where we were all the time. But then without civil liberties, we'd have no protection from the government itself. So, you have to have a line somewhere there. How do we resolve rights about conflicts? This is often politics at its messiest, and there are many involved. So you have the courts, Congress, the president, the people themselves, the courts, the Supreme Court. One of the jobs of the Supreme Court is to arbitrate disputes among things like rights. The Supreme Court is usually the judge of what is fair, but the rulings often change as the membership of the Supreme Court changes. They're humans too, right? The founders wanted them to be above the political fray, but they're still subject to a lot of political pressure. The ideology of the president who appointed them, the influence of public opinion and the media. Congress, they usually stay out of disputes about rights, but sometimes take decisive action to expand or limit rights. For instance, in 1991, there was a Civil Rights Act that broadened civil rights protections in the workplace. And then the president can be involved by lobbying the Supreme Court to encourage them to produce an outcome in their favor. So like in the 1950s, Eisenhower was reluctant to enforce desegregation in the South because he thought it was up to the states and not the federal government. So JFK chose to be more actively involved, and he sent Congress a civil rights bill in 1963. The people, so Americans can sometimes use the courts to sue for what they perceive to be their rights, but they often act in groups. Some groups like the ACLU, the American Civil Liberties Union, they engage in things like fundraising and public relations to publicize their views. All right, so the Bill of Rights and incorporation. The Bill of Rights had kind of a stormy birth. There was a controversy about whether a Bill of Rights was necessary. It really deepened the split between the Federalists and the Anti-Federalists during the founding. And the controversy didn't end once it was added as the first 10 amendments. Over a century passed before the Supreme Court agreed that at least some of the restrictions imposed on the national government should also be applied to the states. So why is a Bill of Rights valuable? Federalists argue that the Constitution itself was a Bill of Rights and that individual rights were already protected in many state constitutions, and to add to the list of powers that a government didn't have was dangerous. In Federalist 84, Hamilton said, by spelling it out, it implies that the things that the government does not have the power to do, it implies that the government has every other power. Madison agreed with this at first, and then he started to agree with the anti-federalists, such as Thomas Jefferson, who wrote that a Bill of Rights is what the people are agreed. A Bill of Rights is what the people are entitled to against every government on earth. The government is limited in principle by popular sovereignty, authority in the people. It couldn't hurt to limit the practice and specific list of rights that would give the judiciary a better check. There are some rights that are protected in the Constitution itself, like habeas corpus, the right of an accused person to be brought before a judge and informed of the charges and evidence against her. Bills of attainder, laws under which specific persons or groups are detained and sentenced without trial. And then state and national government. These they're forbidden to pass bills of attainder. Ex post facto laws. I cannot talk this morning. These are laws that criminalize an action after it occurs. So those are protected in the Constitution itself. The Supreme Court took up making the protections of the Bill of Rights applicable to states in something called incorporation. But not all rights necessarily qualified for incorporation. The Supreme Court had to consider each one on a case-by-case basis to see how fundamental it was. And currently, almost all rights have been incorporated. Incorporation, this is a judicial creation. It's not an absolute constitutional principle. So what the Supreme Court creates, it can also take away. So freedom of religion, let's think about that. When religion and politics mix, the stakes are high, passions are deep, and compromise is difficult. The United States has been spared a lot of violence because of the First Amendment protections, but it's not without controversy. Founders based their religious view on two arguments. History has shown that linking church and state can have a negative impact on secular life. And the second is that the effect that politics can have on religious concerns. They worry that spiritual purity and sanctity of religion would be ruined if it was mixed with the worldly realm of politics that emphasize power and influence. The Establishment Clause is the First Amendment guarantee that the government will not create and support an official state church. And then separationists are supporters of a wall of separation between church and state. Accommodationists say that they're supporters of a government non-preferential accommodation of religion. States shouldn't be separate from religion, but rather should accommodate it without showing preference for one religion over another. That's accommodationists. Separationists say there should just be a wall of separation. The Free Exercise Clause. This is the First Amendment guarantee that citizens may freely engage in the religious activities of their choice. But what about religious beliefs against things like killing, and that clashes with their compulsory military service during war? What about religious holy days that are ignored by state legislation? These are things that you really have to think about. Police power is the ability to protect government's ability of the government to protect its citizens and maintain social order. So if a state needs to regulate behavior, it may. What about a compelling state interest? This is a fundamental state purpose, which must be shown before the law can limit some freedoms or treat some groups of people differently. Okay, freedom of expression. This is one of the most cherished American values, the right to free speech, but Congress makes laws abridging the freedom of expression. We tend to restrict speech we don't like, value, admire, respect. The challenge is to protect the speech that we don't like. So why is the freedom of expression valuable? If you want to participate in a government, you need to participate wisely. You need to be informed. You need to have a watchdog check on government to keep government accountable. And then there's a danger of setting a precedent of censorship. John Stuart Mill said the free traffic of all ideas, those known to be true as well as those suspected to be false, is essential in a society that values truth. We must allow expression of all ideas to discover the truths previously believed to be false. So what about speech that criticizes the government? Sedition is the speech that criticizes the government to promote rebellion. There were early restrictions on speech. In 1798, they outlawed false, scandalous writing against the government. State governments in the South punished speech advocating the end of slavery, and even censored mail to prevent distribution of abolitionist literature. By World War I, freedom of speech and press were a sham for those who challenged the status quo. Getting a sleepy? No, she's just awake. The government clamped down hard on people who promoted socialism, anarchism, revolution, and even labor unions. In 1971, Congress passed the Espionage Act, which made it a crime to engage in disloyal, scurrilous, or abusive language about the form of the government. There were sweeping prohibitions like this that made it possible to arrest people under the flimsiest of pretext. The bad tendency test is the rule used by the courts that allows speech to be punished if it leads to punishable actions. It's pretty easy for prosecutors to meet this test, so most convictions here are upheld. And then the clear and present danger test. This is the rule used by courts that allows language to be regulated only if it presents an immediate and urgent danger. That's kind of the role of the Supreme Court and things like under the sedition laws. Senator Joseph McCarthy conducted some investigations of American citizens searching out communists. There was a House Un-American Activities Committee that did the same thing. Many careers and lives were ruined by suspicion of communism. So the Supreme Court started to overturn sedition. The Supreme Court ruled that the abstract teaching of violence is not the same as an incitement to violence, that political speech could be restricted only if it was aimed at producing or was likely to produce imminent lawless action. So imminent lawless action that test is the rule used by courts that restricts speech only if it's aimed at producing or is likely to produce imminent lawless action. This continues to be the standard for regulating political speech today. Symbolic speech. Many forms of expression really go beyond writing, but should they be protected? When is an action a form of expression? About like burning a draft card, wearing an armband to protest, torching the American flag. The Supreme Court is generally willing to allow the regulation of symbolic speech than of speech alone, especially if the regulation is not a direct attempt to curtail the speech. What about obscenity and pornography? This is probably has presented the Supreme Court with the biggest headaches. In 1964, Justice Potter Stewart said he could only conclude that I know it when I see it. That's something we always joked about in law school. Like, you can't really define what something that is obscene and pornographic is, but you know it when you see it. So the Miller test in 1973 kind of defines when obscenity must be based on local standards. Whether obscenity should it be protected speech? That kind of raises fundamental issues, including defining what is obscene. One man's vulgarity is another man's lyrics, right? Like, is it art? Is it obscenity? Sometimes it's hard to know. What about fighting words? Fighting words is speech that's intended to incite violence. The Supreme Court has ruled that this can be regulated, but it rarely upholds legislation designed to limit fighting words unless the law is written very carefully and specifically. It must have a clear and present danger of serious substantive evil that rises far above public inconveniences, annoyances, or unrest. What about political correctness? That's the idea that language shapes behavior and therefore should be regulated to control its social effects. This movement, the political correctness movement, really swept the country in the 80s and 90s and on college campuses. And then after 9/11, a lot of conservatives treated any criticism of the U.S. as something close to treason. After the 2016 election, there was a Republican primary narrative that overly sensitive liberals have stifled people's ability to express themselves. So it's really, that's a tough one to wrap your head around. The freedom of the press. What about the prior restraint? That is, British common law held that it's acceptable to censor writing and speech about government as long as the censorship occurs after publication. So you look at prior restraint. This is the citizenship of our government for the expression of ideas before the ideas are printed or spoken. Libel is the written defamation of character. Verbal defamation is called slander. The written defamation is called libel. You have the right to a fair trial. Media coverage often leaves it difficult to find an impartial jury, but there's also a public right to know what's going on, right? The Sixth Amendment gives us the right to a speedy and public trial, and journalists often think this is to mean proceedings should be open. But courts are reluctant to uphold gag orders that impose prior restraints on the press. Conflicts between authors and creators of materials to claim copyright of work in public who want to stop access of work without paying for full use. This is something that we have dealt with. I don't work for Congress anymore, but when I worked for Congress, we worked with something called SOPA and PIPA, the Stop Online Piracy Act and the Protect Intellectual Property Act. This is kind of allowing when you're concerned about how you can censor your own work, and then how like companies like Google can also oversee that. You know, you have kind of a variety, have kind of like opposing views there. A lot of sites went dark, like Google, in protest of some of these bills, and it effectively killed the legislation. So how do we protect intellectual property rights on the internet? That's an unsolved issue that we're still thinking about. The right to bear arms. This is a rallying point for those who want to engage in sporting activities involving guns. A lot of you guys mentioned the right to bear arms when I asked about some things that are important to you when you were creating your own campaign. It's a rallying point, and people believe that an armed citizenry is necessary to check government that might become tyrannical. Oh, baby. And those who don't believe that it's the government's business to make decisions about who can own guns. What are we fussing about? There are various kinds of gun control passed at state and local levels, but the National Rifle Association keeps it to a minimum at the federal level. Why is the right to bear arms valuable? It's the chief source of national stability in early America was a state militia system. The armies of able-bodied men who could be counted on to assemble with their own guns to defend their country from external and internal threats. So the Second Amendment was designed to guard against the tyranny of the federal government. What are some of the arguments in defense of the Second Amendment today? a lot of people, after we had a U.S. military, a lot of people thought of the Second Amendment as obsolete because we don't really have a militia system anymore. But the NRA and others insist that this is still relevant. They say that hunting and other leisure activities are important to American culture, and that restricting any of them is the start down a slippery slope. The slippery slope argument is always a pretty good argument when you're looking at things like that. Possession of guns is necessary for self-defense. Gun control means only criminals who will get guns on the black market will be armed, and life will be even more dangerous. And then citizens should have the right to arm themselves to protect their families and property from tyrannical government, just like the revolutionaries did. And then fourth, it's not the government's business to regulate gun use. What about some arguments against the right to bear arms? I think probably most of you guys were in favor of the right to bear arms, but some of you maybe are opposing the right to bear arms. Some of those arguments, they really have struggled to create a single compelling counter narrative of their own. They argue that gun owners want to make this an issue about rights because they believe that gives their claims a higher status in American discourse when the issue is merely about wants and preferences. They argue that none of the rights of Americans, even fundamental ones like speech and press, is absolute. So why should the right to bear arms not carry any exceptions? And they say that the irony of claiming the protection of the Constitution to weapons that can be used to overthrow the government. Let me say that again. There is an irony in claiming that the protection of the government to weapons, the protection of the Constitution to weapons that could be used to overthrow the government is exactly what the Constitution protects. So it's just an ironic thought there. Okay, what about the rights of criminal defendants? Half of the amendments in the Bill of Rights are devoted to protecting the rights of the people who are suspected of or accused of committing a crime. The founders were really concerned with an arbitrary government that could accuse and imprison people without any evidence or just cause. People are innocent until proven guilty. This comes from our English roots. We have a due process of law, the guarantee that laws will be fair and reasonable, and that citizens suspected of breaking the law will be treated fairly. We have our procedural government here, procedural rights. Like we have those who are treated. You are supposed to be treated fairly when you're suspected of breaking the law. Maybe that is not necessarily the case, but it's supposed to be the case. Founders were really sensitive here under unreasonable searches and seizures because the King of England had the right to order the homes of his subjects to be searched without cause and to look for any evidence of criminal activity. So the Supreme Court interprets our Fourth Amendment to mean a person's home is private and cannot be invaded by the police without a warrant, obtainable with only a good reason to think that the criminal evidence lies within. What's reasonable? There are a few exceptions to search warrants. Automobiles are a special case since by their nature, they are likely to be gone by the time an officer gets a warrant. They can be searched without a warrant if there's probable cause to think the law has been broken. The Supreme Court has gradually widened this search to include luggage in the car. Wiretapping and electronic surveillance, a little more difficult. Search was understood legally to require some physical trespass, and seizure involved taking some tangible object. What about a cell phone? Prior to the contents of one's pockets, which can be legally searched. In 2014, John Roberts, he's the Chief Justice of the Supreme Court, said the average smartphone user has 33 apps that can form a revealing montage of the user's life. How many apps do you have on your phone? Our phones are mini computers that contain a lot of information about us, almost the same that a house may be traditionally contained. And just as a house cannot be searched without a warrant, now neither can cell phones, but warrants aren't hard to come by. So people who store information on their cell phones should be cautious. Do you think anything that you put on your phone is private? I kind of just assume that nothing is private anymore. But kind of like we talked about earlier, I assume that things can be accessed because the government is trying to protect against bad things. Maybe that's naive of me. But I kind of just assume that nothing I do on the internet, nothing I do on my cell phone is private. What about random testing for drug or alcohol use? It's an unreasonable kind of search, but the Supreme Court allows them when the violation of privacy is outweighed by a good purpose, like discovering the cause of an accident, preventing drug use in schools, preserving public safety by requiring random drug tests of like an airline pilot. The exclusionary rule. This is a rule that created by the Supreme Court that evidence seized illegally should not be used to obtain a conviction. So even if the police have concrete evidence of a criminal activity, if it was obtained unlawfully, it can't be used. In England, it can be used, but the defendant can sue the police. This kind of deters misbehaving police, but not allowing guilty people to go free. So the American exclusionary rule helps criminals avoid punishment, but it deters the police. They carve out a good faith exception whereby evidence is admitted to a criminal trial if obtained illegally, if the police are relying on a warrant that appears to be valid at the time, or on a law that appears to be constitutional. In 2009, to trigger the exclusionary rule, they decided that police conduct must be deliberate. Okay, so the Fifth Amendment provides for protections for individuals, including not being a witness against yourself. This expands to grand jury, legislative investigations, and police interrogations. In 1966, Miranda versus Arizona, we know about our Miranda rights, right? In this case, the police had to inform suspects of their rights to remain silent, to have a lawyer present during questioning, to prevent them from incriminating themselves, the Miranda rights. If a lawyer can show the defendant was not read his Miranda rights, like the exclusionary rule, it could result in the police interrogation not being admissible in court. So, if you confess, but you can say, the police never read me my Miranda rights, your confession may change the admissibility in court. This results sometimes in criminals going free, even though evidence is there to convict. So it really get hung up in procedural rules here. But in the year 2000, Miranda was upheld as an established part of culture. So everybody knows that you need to have your Miranda rights read. And I have a sleeping baby now. Apparently me just chatting puts her to sleep. Hope I'm not putting you all to sleep. Right to counsel. The Sixth Amendment right to have a lawyer present during police questioning. The Crimes Act of 1790 required courts to provide counsel for poor defendants only in capital cases. Defendants in other trials had right to counsel, but the government had no obligation to provide it. The right to counsel is really now seen as essential, but often it's violated because maybe an overworked public defender can really limit who can receive court-appointed counsel. Protection against cruel and unusual punishment. The Eighth Amendment says that cruel and unusual punishment shall not be inflicted. This reflects the concern of English law, which sought to protect British subjects from torture and inhumane treatment by the king. But what is cruel and what is unusual? The Supreme Court says not all unusual punishments are unconstitutional, because all new punishments, like electrocution, lethal injection, are unusual when they first appear, but maybe they are more humane than old punishments like being hanged or shot. They're not ruling that the death penalty in itself is cruel or unusual, except for in cases of mental retardation, juveniles, and crimes that didn't result in the death of the victim. A lot of states have death penalty laws. The right to privacy. Why is the right to privacy valuable? It's not spelled out in the Bill of Rights, but it goes hand in hand with the founders' insistence on limited government. They wanted government to not be too powerful and interfere with individual citizens, which implied a right to privacy and assumed it, but it was not made explicit. It's obviously desirable that we should be left alone to do what we want. Does it need a defense? But the right to privacy without limits is anarchy and the absence of government altogether. There's an interest in preventing certain types of behavior, murder, theft, rape. But what about more subtle behaviors that don't directly affect the public safety but have serious consequences for the public good, like prostitution, drug use, gambling, maybe riding a motorcycle without a helmet? Should this be private behavior or should it be regulated by the state? The Supreme Court didn't discover privacy until 1965. And whether such a right still exists is controversial. All of the Bill of Rights include limitations and contradictions, but the right to privacy is the least certain of all. What about reproductive rights? Until the Civil War, abortion bans were uncommon. Most states allowed abortions in early stages of pregnancy, but opinion turned after war, and by 1910, every state but Kentucky made abortions illegal. In the 1960s, the legislation was becoming more liberal, but abortions were still mostly unobtainable. In 1973, Roe versus Wade. This was right to privacy. This said that the right to privacy did indeed encompass the right to an abortion. It tried to balance a woman's right to privacy and reproduction with the state's interest in protecting human life. In 2007, partial birth abortion ban was upheld, but this was not a signal that Roe versus Wade would be overturned. Abortion's really become a partisan issue. A lot of the Christian right make up a lot of the Republican Party. Republicans usually include a commitment to abortion bans as a constitutional amendment in their presidential party platform. This is usually directed efforts at the states. Gay rights. If there's a right to privacy, what might be under it? There are some cases in 1986 and 2003 regarding whether there is a legitimate state interest in regulating this behavior. In 2003, Lawrence versus Texas, the Supreme Court finally overturned this 1986 case on privacy grounds. So it's not as much of an issue. In 1990, the right to die. I'm sorry, it is an issue. We're just that. I don't mean to be offensive. Just kind of trying to read through this quickly. If there's a right to privacy, what needs to be included under it? And that probably, anyway. The right to die. In 1990, there was a woman who'd been on life support since 1983. And there was, her parents had argued that they wanted to withdraw life support and allow her to die, but the state claimed an interest in the sanctity of human life and blocked the request. They argued that a right to die was protected under the right to privacy, but the court said this woman's wishes were unclear without a living will, and her medical treatment was protected under her 14th Amendment due process clause. In 2005, a similar case, Terry Schiavo. I remember this happening. I'm sure y'all don't because y'all are really little. She was in a vegetative state for over 15 years, and her husband said she didn't want to be kept alive by artificials and asked to have her feeding tube withdrawn. This prompted a lot of Americans to consider getting a living will. Does our government have a right to keep us alive? Do individuals have the right to assistance in ending their lives when they're terminally ill or in severe pain? Should a patient decide? Would it violate a doctor's Hippocratic oath? In 1997, the Supreme Court said it should be left to the states. Okay, rights come with obligations. We've talked a lot about the Bill of Rights, but what would a Bill of Obligations look like? Obligations are the flip side of rights. For every right guaranteed, there's a corresponding duty to use that right. Provisions for an elected office imply a duty to vote. Congress is authorized to collect taxes, and citizens are obligated to protect those taxes. In Europe, such obligations are explicitly extended to include providing for the welfare of those who cannot take care of themselves. Tax burdens are higher, and sometimes the obligation to vote is legally enforced. We don't legally enforce the right to vote here. It is a right to vote. It is not an obligation. How much fulfillment is enough? We obey most laws most of the times. If we don't pay all of our taxes, we pay most of them. If we don't vote, we get involved in other ways. We are getting by as a nation for now. But perhaps we should consider the long-term consequences to a democratic republic if the emphasis on preserving civil liberties is not balanced by a corresponding commitment to fulfilling political obligation. I'm going to talk a lot about how important I think it is to vote, and especially this is a good time of year to be emphasizing that to you guys. Probably not many of you are able to vote yet, but I think it is something that's very important. We are not obligated to vote, but we have the right to vote, and it's very important to recognize the differences between the two and exercise the rights that we do have. Okay, so I want you to think about, here's your question that I want you to get back to me on. I talked about this kind of at the beginning. When we are balancing security and freedom in our country. So for instance, after 9/11, when they decided that it was okay to start going through our belongings at the airport, and the balance between security and freedom, on which side should we err? When do you think it's okay for the government to take some of our freedoms away when they are looking for increased security? Just think about that. And the delicate balance between security and freedom, on which side should we err? Should we err on the side of security? Should we err on the side of freedom? What is more important, security or freedom? Email me your answer to that by 9 o'clock on Wednesday morning. And I will come back with another video for you. And then I'll give you some instructions about our exam next week. Remember, your exams are 20% of your grade each. So you should be sure and start studying for those. And email me by 9 o'clock Wednesday morning. And the delicate balance between security and freedom, on which side should we err? Security or freedom? All right. Have a good one. Bye, guys.